Hey everyone, it's Eugene Lee Show, and welcome to Forensics Talks. This is episode 64, and today my guest is Chris Fabricant, who's going to be speaking to us about junk science and the American criminal justice system. We are live streaming to YouTube, Facebook, and LinkedIn, and now we are also doing podcasts. So after this is done, I will put this episode up at some point in the future up on your favorite podcasting service. And also in the chat window, if you can, please go ahead and just let us know where you're from. Hope we're getting some visitors from all over. We usually do, and which is quite interesting to see. And also remember, there are comments here. So along the way, if you have any questions at all, please go ahead and then just put them in here. So we're just going to get started right away. It's been some time. We've had a little bit of a break. So yeah, I feel almost nervous. It's like I got to do a reset here and start over again after having these scheduled pretty frequently. Let's start with a little brief bio. And so today, Chris Fabricant. So he's the director of the Innocence Project Strategic Litigation Department, whose attorney develop and execute national litigation and public policy strategies to address the leading causes of wrongful conviction, including eyewitness misidentification, the misapplication of forensic sciences, and false confessions. Chris is one of the United States' leading experts on forensic sciences, scientific litigation, and the criminal justice system. As a former public defender and clinical law professor, Chris brings over 2 decades of experience ranging from litigating death penalty cases in the Deep South to misdemeanors in the South Bronx. He frequently serves as a public speaker on legal reform and social justice, and he's published numerous articles in journals such as Fordham Law Review and New York University Review of Law and Social Change. So Chris has been featured in the Netflix documentary, The Innocence Files, and his public commentary has been published in many major media outlets. You can find him on the news. He's been on YouTube and a number of different areas. And this past year, Chris released his new book, Junk Science and the American Criminal Justice System, where he examines the role and impact that faulty scientific evidence has in the criminal justice system. And that's what we're going to be talking to him about today. And let me bring him up here. Hey, Chris, how you doing?
Good. How are you?
All right, I'm great. Thank you very much for your time today. I really appreciate you being here. Yeah, I normally start like a lot of other people asking about, how somebody got started and that sort of thing. But in your case, I'm actually going to step back before you got started, which is an interesting story that I caught wind of having to do with your parents. And you're a second generation public defender. So I was wondering if you could tell us about how your parents came to meet. It's an interesting story.
Yeah, I mean, in many ways, I'm the product of the drug war and a product of mass incarceration policies. And that in 1969, my mother was busted for trafficking hash, and my dad was a public defender at that time in the Legal Aid Society here in Manhattan, and represented my mother. And so the product of that union is me, the brief union. It's not a great way to meet your future wife, but that's the way that it went down. And, and I ultimately came and followed in my father's footsteps, although not in terms of my life partner, who happens to be a therapist.
Okay, right. And then what about your path then to law? Was it something that you said, hey, my dad's doing this, it's really interesting, I'm gonna do this too, or did it change along the way? What was your path there?
I always wanted to be a public defender, and I always wanted to be a writer. I mean, those are the two things that I thought were going to animate most of my career. And in many ways they have. It's challenging to make your living as a writer, and because I'm animated by my sense of justice, and that's kind of what gets me out of bed every morning. So I knew I was going to be a public defender, and I knew that when I was in law school, and I was clerking at the Public Defender Service in Washington, D.C., which is one of the premier public defender shops in the country. And, I went straight into, after I clerked for a couple of years, I went into appellate work. I was a public defender on appeals. So that's much more of a cerebral job and more kind of research and writing heavy. And then I was a trial attorney with the Bronx Defenders for a while in the South Bronx. And then I was a clinical law professor. And then when I was teaching, I was developing strategic litigation strategies to address mass misdemeanor arrests and stop and frisk issues. And that was kind of led to the kind of work in strategic litigation. And so when the Innocence Project decided that they were going to start a strategic litigation department, I applied, and I've been in this office for 10 years now. So
Okay. So talk to me a little bit about the Innocence Project, and maybe a lot of people just know it as, they help free people or whatever. But what else could you tell us about sort of the structure and the organization? I was on the website just before, and I can't believe how many people are involved. It's huge.
yeah, we have an excess of 100 employees here in our offices in New York City. And we are kind of the hub of the wheel of the Innocence Network, which has over 60 organizations around the world that are devoted to freeing the innocent and changing laws to prevent wrongful conviction and to help free the innocent. So, our work has, this is our 30th anniversary this year, and, a lot of things that I write about in the book is just how much, that we've learned as a result of the Innocence Project's work about the fallibility of our criminal legal system in this country.
Okay. You mentioned before, and it was something that I wanted to ask you, so maybe it's a good starting point, about mass incarceration. And so, what happened, in that early time, like the 50s, 60s, 70s? Like, what was going on that was causing this, mass incarceration? What kinds of things were happening in the legal system?
We can't really look at our criminal justice system in a snapshot from any particular decade. What you have to go back to is it's been our criminal justice system has been used as the principal means of social control of marginalized communities in this country for hundreds of years, and primarily and overrepresented Black and brown people in this country. So, there's a lot of very good scholarship, probably most famously Michelle Alexander in her book, The New Jim Crow, that talks about, the direct arc from slavery to which was enforced through our criminal justice system here in this country, to Jim Crow laws, which are also enforced through our criminal justice system, to mass incarceration. Mass incarceration, as you point out, really started to ramp up really right at the end of the Jim Crow era and the beginning of the drug war. And, and I have done a lot of research. I wrote a book about the drug war many years ago, and there is the arc is, it stops there and then it skyrockets with the drug war that has dramatically disproportionate impact on marginalized communities and has led directly to mass incarceration, along with the the Anti-Terrorism and Effective Death Penalty Act, which I talk a little bit about in the book. And so it's kind of sawed off any avenues of relief in federal court for excessive sentences, for unconstitutional convictions, for wrongful convictions. So now, the means of kind of escaping a wrongful conviction or, an unjust or an unconstitutional conviction is really, really challenging. And it gets more challenging with every Supreme Court decision around the AEDPA.
Yeah. You also talk about and maybe you can comment on this, is it's like the development of a new industry, almost like with expert witnesses as well. So as there was a need for people to start testifying and talking about, different subject matters, which some of which we're going to talk about today. But what can you say about that?
In that same era that you were just pointing to, in kind of the post-World War II era, and, but then, beginning in really the 1960s and 1970s, our legal system just grew exponentially on both sides, right? On the civil litigation side, we had this explosion of personal injury litigation and class action litigation, product liability. And a lot of plaintiffs' attorneys were getting very wealthy, suing corporations for liabilities. Many of those lawsuits were based on junk science. These were experts that were speculating and without any real basis for their opinions that were being offered as sometimes scientific evidence or expert witness testimony. And a cottage industry kind of sprung up to support this type of litigation. And so, to be clear, a lot of it was pretty righteous, right? Ford Pintos were taken off the streets, and some of the other, kind of dangerous, products. But there was also a lot of bogus litigation. And at the same time, we're having this ratcheting up of the criminal legal system side of our legal system with the drug war that we were just talking about, and just this explosion of, the prosecutorial mindset of our country and getting, cracking down on, crime. So both of these forces kind of grew our legal system just exponentially. And on the civil side, the corporate defendants were getting tired of being sued and being tired of being sued on speculative evidence and losing because their, plaintiffs' attorneys were putting forward very sympathetic people that may or may not have been victims of corporate malfeasance. So they teed up a case to the United States Supreme Court called Daubert, and it looks like it should be Daubert, but I'm told by people who know the Dauberts that that's the way they pronounce their name. So so what they wanted, the corporate defense bar wanted, was a new standard for the introduction of allegedly scientific evidence, right? Before that, courts were deferring to the relevant scientific community, saying, if the scientists agree, who are we to say otherwise? It comes in. But, the way that they were defining the relevant community was often experts who had a financial and ego stake in the continued admitting of this particular type of evidence. So it didn't lead to very rigorous results. So the idea was that courts were going to have to start doing their homework and applying kind of basic scientific principles to the proffer of expert witness testimony to see whether or not it passed muster. And as a result, they won. Daubert was, it became kind of the law of the land, except for, many 7 states, I think, in this country still have the old standard, but Daubert is pretty much the standard around the country now. And what that was is that we're going to try to screen out speculation masquerading as scientific evidence. And it worked. At the civil side, judges began excluding unreliable evidence in numbers that had never been seen before, right? But nothing changed on the criminal side. And I document it like this in my book, and I talk about a study that Peter Neufeld, the co-founder of the Innocence Project, did about 10 years after after Daubert, that showed that criminal defendants were almost never successful, virtually never successful in excluding alleged, scientific evidence. And prosecutors were always successful in not only getting their evidence in, but in challenging defense experts. On the civil side, there was change. On the criminal side, there was no change. And even after the Innocence Project began exonerating people and demonstrating the unreliability of so many of these forensic techniques that I talk about in the book, still, and this was from a follow-up study that I did with Professor Brandon Garrett from Duke in 2018, that showed that nothing had changed, despite nearly half of all wrongful convictions overturned through the use of post-conviction DNA evidence are attributable to the misapplication of forensic sciences. Mm-hmm. And yet courts have done nothing to change that.
Yeah, and I would say that that's been my observation as well. It's very difficult. In fact, I'm trying to think about any case that I know of where a judge has said, hey, we're not going to let this person testify. I mean, I'm sure it's happened, but it's very, very rare. Maybe sometimes they limit the type of evidence that's being presented. They'll put a cap on certain things, but, to really say, hey, look, we're not going to go there. It's pretty rare. It's very rare, as you say, and it's kind of important.
Judges pass it to the jury. They say, yeah, we're going to let the jury sort it out. And jurors, like most of us, are scientifically illiterate. That includes judges, that includes lawyers, that includes jurors. So having separating sense from nonsense in the course of a trial doesn't work, as we see from wrongful convictions.
Yeah. And the jury is subject to different influences and such. So, for example, have you seen the expectation change from the juror's perspective because of TV shows and documentaries and all that other stuff?
Absolutely. When was the last time that you saw a CSI type show that showed that, the forensic scientist made a mistake? That it was junk science that was being applied in a particular case? That never happens, right? The procedurals always start with, a crime, a suspect is developed, charge is often, then we do some forensic testing, right? And it's perfect, it's accurate, it's quick, it's objective. We got the bad guy, we have some trial drama, we have a conviction, wrapped up, and that's the way that the overwhelming majority of Americans understand our legal system. That's, fairly representative of it. I've had clients that were featured on shows like Forensic Files, including Alfred Swinton, right? There's a picture of Alfred Swinton right there on my wall, emerging from court after his exoneration. He was depicted in Forensic Files as a serial killer. We looked at that case and we were just like, he seems innocent. If you're skeptical about bite mark evidence, which of course I am, he seemed innocent to me. We have another client that was on Forensic Files, Jimmy Genrick, who's like alleged to have committed a series of bombings, and the only evidence that they have in that case is handheld tool mark evidence, and they say that one wire stripper made one mark on a 2mm piece of wire, and that mark itself is 1/100th of an inch. That wire stripper, a knockoff pair of wire strippers from China, how many zillions have been made, is the only wire stripper in the world that could have made that particular mark.
Right. Yeah, I understand. And it's not like there's a mountain of evidence and research on wire strippers and things like that, right?
There's
So
none.
yeah, I understand. What was the impact, in your opinion, of the 2009 NAS report that that started talking about all the different these subjective methods and these different disciplines that needed a lot of work? Like, how did that help or affect you, yourself, your team, and the Innocence Project?
You're doing forensic talks. I doubt that you have many interviews where the 2009 NES report isn't at least mentioned. It was the thunderclap across the forensic community and across the criminal legal community. I mean, in particular, when I started here in 2012, so I had been a public defender for a long time before that, and it was a staggering document to me. I think about all of the pleas I took on, with hair microscopy, and I didn't, think that these were even challengeable techniques, because I wasn't thinking critically about it. So when you have the most prestigious scientific organization in the country, if not the world, that was taking the first real hard look at the claims that were being made there, and finding them all really seriously lacking, and opinions like the one that I just talked about in Jimmy Genrick's case are just, absurd, that were being accepted routinely today. Right now, right down the street in 100 Center Street, you can still find, individualization type techniques that don't have a statistical basis to make those types of claims still being accepted. So I think that the conversation that started with the NAS report has been the most important, apart from the work of the Innocence Project and our sister organizations around the world. The two things really that have really propelled change, to the extent that we've had change, have been wrongful convictions and mainstream scientists taking a hard look at some of the claims that have been accepted by criminal courts for a century.
Mm-hmm. And in your book, on the front cover of the book, you've got, obviously there's a dentition there. So you go after bite mark, the whole bite mark analysis pretty hard, but you mention other areas, like you talk about, fire arson, you talk about hair, and fiber analysis. You talk about what was the other one? The lead, is
Compared
it
to bullet lead analysis,
comparable lead analysis, right?
Hair
So you talk
microscopy, voice spectrometry, blood spatter evidence, shoe prints, or wear impressions, right?
Right. There's a whole bunch. So which of those for you? Obviously, the first case you said was in 2012, I believe, that you took,
Mhm.
and it was a bite mark case, correct?
Yeah.
Or
So
no?
what the first client that I had at the Innocence Project was, and this is one of the backbone stories in my book, is Stephen Chaney. And, Mr. Chaney had been convicted of a gangland style massacre of two drug dealers in Dallas, Texas in the 80s. It was a young couple that each of whom had been stabbed over 20 times and had their throats cut and left in their own kitchen. And they had no suspects, but thousands of suspects, because it's a dangerous business to be in drug dealing, and there had been prior threats in their lives, not by Stephen Chaney. And Mr. Chaney had been a casual cocaine user at that time, as in the 80s, it was believed not even to be addictive. And these two people ended up dead. His fingerprint was found at the scene, which was not surprising, given that he'd been there many times. Somebody claimed that he owed them money, and that this was developed as like a motive to slaughter two people because he owed them $500. And, the whole investigation turned when they got that testimony, or that SNIT's testimony that says, hey, Stephen Chaney had this motive. Then they found a fingerprint. And then, because these are subjective techniques, then you start painting a bullseye around a target, right? They have Stephen Chaney. So suddenly they seize the sneakers, right? And they do a presumptive blood test on the sneakers. They don't do the confirmatory, and they bury, an exculpatory one later, but they present it as blood. And then they associate his sneakers with the blood-stained shoe prints in the kitchen floor on that case, right? And then he flunks a lie detector test, allegedly, right? And then they find, an alleged bite mark. And I show a picture. There's a picture in my book of of what they claim the actual bite mark was. And it looks to me like, a brand or something like that. But that's the beauty of bite marks, is that it's in the eye of the beholder, right? And so you can look at it. It's like looking at a cloud formation. You say, hey, doesn't that look like an elephant? And you go, hey, Eugene, yeah, it does, right? And then you can't unsee the elephant, just like bite marks, right? So, oh, yeah, it's a bite mark, right? So then they specified 1,000,000 to 1 that it was Stephen Chaney, and he was my first client.
And that's the one, the odontologist there, I believe his name was Jim Hales. But then what was interesting is he had an opinion on something, but in your book, you point out that, for example, the opinions start to become firmer and firmer, and they change as they get closer to the trial date, right? Like in some cases, like the night before, the experts.
When we find out about it, right? We see this in case after case after case after case, is that forensic experts are pushed implicitly or explicitly by prosecutors who have a firm belief in the defendant or the suspect's guilt, right? So they're believing typically, and there are bad actors, of course, notable exceptions to the general rule, that I think most people are acting in good faith, believing that they're out to get at the bad guy. And and having kind of inconclusive or types of opinions aren't that helpful in a criminal trial. And so you see this, like in Stephen Chaney's case, this is true. In Keith Harward's case, this is true. And then we see this, as you move closer to trial, suddenly an opinion becomes that's the guy.
Mm-hmm.
We see that in the Charles McCory case in Alabama that we're litigating right now, an obviously innocent man that we can't get out of prison because bite marks are still admissible in Alabama.
Right. And in Chaney's case, though, it's kind of interesting because, and I don't recall who it was, but it was DNA that eventually, there was some DNA under, like, the woman who was killed. She had some fiber or hairs and stuff like that. But they actually had somebody called Juan Gonzalez, right? Was he actually the one who did it in the end, or did they find who did it?
So the couple of things about what you just said is that one is that there were two victims, right? And so Mr. Chaney was only convicted of murdering one because that's the only one where they had alleged physical evidence associating him with the husband, right? Because the bite mark, right? So there were two victims, and about 10 years before I got the case, there had been DNA testing under the victim's fingernails that had a mixture of DNA, 3 male profiles, none of whom were Stephen Chaney, and hairs clutched in the hand that were dark hairs, so potentially, somebody of Hispanic descent, maybe, that was but Stephen Chaney had blonde hair. So that DNA testing wasn't enough to exonerate him. And so he ended up going back to prison, and nothing ever happened with his case until we started the strategic litigation department here and started looking for people that had been convicted on junk science. And bite marks was the top, the junkiest, and then we started looking for those types of cases. I talk about that in the book about how we went about that. And so, Stephen Chaney's public defender reached out to me to see if we had an interest in helping represent him, and then, we did. And, so much reform and so many people had to work on that case, both individually and as a field, that resulted in ultimately Mr. Chaney getting out of prison. And he's one of them, 1 in a million, and I write about like kind of what it's like as an Innocence Project lawyer to meet a client in prison for the first time, is that they feel like they've won the lottery. And of course they have, right? Because there are 2.3 million people incarcerated in this country, or various forms of incarceration. And, we have a handful of lawyers here, right? So we're hardly getting to all the innocent people,
Mm-hmm.
And so it's just really lucky to get an Innocence Project lawyer.
Yeah, I want to ask you a question. There's a section in your book where you talk about the principle of finality. What are some of the reasons why it's so easy to convict somebody, and why is it so difficult to exonerate somebody?
Well, one is that any criminal defendant walks into court with two strikes against them. And one of the arson cases I talk about, a prosecutor admitted that out loud. When he decided to dismiss the indictment in a junk science arson, potentially, a junk science wrongful conviction. And so there's that. And the truth is, and people are sometimes surprised when I say this, is that most people that are indicted and go to trial are guilty of at least some of the crimes, or
Hmm.
some of the offenses that they've been charged with, right? Imagine we lived in a society where that wasn't true, but we also talk about, 2.3 million people. If we're talking about 1% of them have been wrongfully convicted, which I think is conservative, we're talking about tens of thousands of people. So it's not a small problem. But once you're in trial, and this is particularly true when alleged scientific evidence is proffered against your client, you're not going to be able to cross-examine your way out of that case, right? You can have, my boss Barry Scheck, out there, pounding the podium on your behalf, and the likelihood is that you're nonetheless going to be convicted. And so we have always advocated for a long time at the Innocence Project for upstream fixes. And the idea is that we need to do the validation research in a laboratory, and we need to do it in a laboratory that's separate and apart from law enforcement, right? And that was one of the chief recommendations from the 2009 NAS report. We need something like the FDA that's going to do the validation research, although the FDA doesn't actually do research, but that to do the research someplace like NIST, and to demonstrate its reliability in the absence of the adversarial system, right? Because that is not going to work out.
Hmm.
Because then you're talking about human emotion, and you're talking about peoples, and you're talking about victims, and you're talking about lawyers that are going to be biased on behalf of their position. That's their job, right? And that's not a scientist's job. A scientist's job is to be objective, right? And go where the evidence leads, where the research leads.
Right.
So that's the conviction. Overturning conviction, because of the principle of finality, which is like the reigning principle in our courts, which is why we have the AEDPA to begin with. That's the basic idea, is that we're going to stop, with the appeals. We're going to stop attacking convictions, because once a jury has spoken, that's final. You're entitled to a fair trial, and that's it. So that principle is used again and again to deny relief for innocent people.
Yeah, that makes sense. How would you define junk science to you?
And I wanted to be really careful about the way that I define junk science in this case, because we have a policy department that works toward improving the scientific bases of the forensics that are used in our justice system. And of course, I support those efforts. We all do. And so what I defined it as in the book is subjective speculation masquerading as scientific evidence, and that it sounds like science, but there's no empirical basis for the opinion, that it's relying almost entirely on training and experience. And this is like often, passed down through guild-like structures, or these board certifying entities like the American Board of Forensic Odontology,
Hmm.
where you just have this received wisdom from very, esteemed figures in the field. They bring on mentors, and they teach the same things that they were taught, right? And that's not how science should work, right? Science should be developed in a laboratory like DNA was. So that type of structure, leads to this kind of perpetuating bad science.
Hmm. In the book, it almost sounds like, yeah, I mean, you go after the odontologist pretty hard, but like they're a group and almost like a club, and it's almost incestuous. They help each other on cases and different things like that. But what about? I mean, would you support things like academic institutions taking some of this stuff on?
Absolutely. What a lot of the work that I do is with mainstream scientists, that are academics. And this is particularly true because you talk about these board certifying entities or these guilds, is that their whole livelihoods and their professional egos are dependent upon this field, right? And so there are, unlike many other sciences, there's really almost no application for forensic techniques outside of the criminal justice system, right? So if it's not accepted in criminal courts, it's useless. You don't need a ballistics expert in your everyday life, or bite
Hmm.
mark guy or anything like that, right? It's like, so as a result of this, right? I mean, is that you have very kind of tribal, approach to an entire field, and you won't get dissenting experts in those fields. And I write about some of the dissenting experts that have worked with us and how they've been attacked. I mean, and that happened to a group of pathologists who signed on to E.T.L. Jor's recent paper, were attacked in ethics complaints are filed against them. That happened in forensic dentistry as well. So it's very, very hard to have a dissenting opinion in that community, right? And
Hmm.
not only for those reasons, but also this are often taught by mentors that they highly respect. And these are intelligent people, right? These are not dummies, right? These are, there are whole textbooks that are devoted to this, I mean, and people that are, making a lot of sense. It is like the medicine, for example, that I draw these parallels in the book is like, was the same until like the 1980s, right? And they weren't doing evidence-based medical decision making for centuries before that, right? It
Hmm.
was very much based on the esteem of doctors and received wisdom of the field, and some of it was good science, and some of it was nonsense. And the Corcoran Collective, right, was the first, similar to the NES report. People from outside of medicine came and looked at the evidence and saying, I mean, like, a lot of this is wrong. I mean, it's demonstrably wrong and speculative. And the doctors flipped out. It's like, who are these, outsiders and statisticians telling us, what our business? We're doctors. It's like,
Hmm.
but then eventually, and I make this point as well, it's like what the customers, right, the patients, they started to demand evidence-based medicine, right, because we know it's better, right, and we know
Yeah.
it's more accurate, right, it's better science. The customers in the criminal justice system are primarily prosecutors, and they aren't pushing for reform in this way, the same way the defense community is.
Yeah. Let me bring up a comment here because I think this is actually one of the questions I had. And this is from Jeff, and he says, why use the term junk science rather than the misapplication of forensic science? And so sometimes you get people, you'll say, what do you say to people who say we hate the expert but not the science?
Right. So I use the term junk science very explicitly, right? So I didn't call fingerprints junk science, for example, right? But there have been wrongful convictions attributable to the misapplication of fingerprints. So, for example, I believe, like most people, that latent fingerprints are not latent. Fingerprints are probably unique, right? That's not a scientifically validated fact, but I believe it probably is, and they're at least highly discriminating at the very least, right? So, but you can take that valid field and make it pretty junky if we're talking about a smudge at a crime scene and a latent print, and you don't have enough information. And critically, we don't know how rare, how common gross features are, right? Or how similar two prints might be. And when you're talking about a small amount of information in a crime scene, that's when you can have random matches.
Hmm.
And that's when you can have the real influence of close non matches. And that's where cognitive bias will influence that decision. So, in my view, and in the way that I've defined it in my book, that would be a misapplication of a forensic technique that's otherwise valid if it's done with enough information. And importantly, we don't know how much information we need before we can make an accurate, identification.
Hmm.
And then junk science, as I defined it before, is something that can't be done. Period. Right? What I mean? Is like there's no value to bite mark evidence. Right? It just simply can't be done. Right?
But do you think so? Because isn't it the same? I mean, let me ask you this. So, for example, the skin comes up always as as an issue because it stretches and it distorts. But if you think about fingerprints, it's actually not even on a hard surface like a dentition. It's actually on the skin, which is distorting and everything else. So, are we talking? I mean, I think there's a number of issues here that you've mentioned already. Like you're talking about the quality of evidence. Like so, in a fingerprint case, you can have, hey, we can make a clear ID here, or you get to a point where it's like, wait a sec, we got a problem. And the same goes with DNA. DNA can be like, hey, this is a clear cut case, and all of a sudden, oh boy, we got a mixture of like 5 people here. We got to figure this out, right? And then
Right.
that's where we start. So the quality of evidence is important.
Mm-hmm.
The expert is important. For sure, the discipline, the science, the research, the backing, the methods, all those are important too. So I think we differ a little bit on this, but I think
Let
it
me
is
try to
a
persuade you. All
yeah.
right.
Go ahead.
It's like, because we're talking about the fingerprint that you just mentioned, but that's not the substrate that the fingerprint is in, right? If this fingerprint is on an ever-changing substrate, then you have a real problem, right? So you think about like the most basic thing, right, is that you see an injury, that on a dead body.
Mhm.
Usually it's a day, 2 days, whatever it is later after a homicide, that a forensic dentist will document this injury. We have no idea what position that body was in when the injury was inflicted, or how long it was, or what kind of struggle was going on, or how much of that mouth, even if it was a mouth, that made that injury. And we have no idea how much that injury has changed as a result of decomposition process, right? So you could have somebody who matched one day and doesn't match the next because the injury continuously changes. And with a
Mhm.
live person, it's swelling, it's healing, it's all these other things that also create change, right? So right there, right? You just can't have a reliable field that's based on something where you can't predict the way that something is going to change. It's totally unpredictable, and there's no literature to support that. So putting that fundamental problem aside, right? Just the idea of identifying a human bite mark, distinguishing that from all the other things that have been mistakenly believed to be bite marks, is the evidence is that the forensic dentists are no better than you and I would be, and it's like flipping a coin, right? The construct validity test that Dr. Adam Friedman and Dr. Ian Pretty did demonstrates that board certifying experts really are no better than you or me, or flipping a coin as to whether or not something is even a human bite marker, or not. And so then, we could go into other problems, but those two are full stops, like, because they're not really surmountable problems.
Well, I don't know. See, so I see them as an opportunity, and because I feel like, and again, I'm not trying to get combative here, but I
We
don't
can
want to
look
throw,
at it.
I don't want to throw the baby out with the bathwater. So
I think I said that exact phrase in the book, is that like the proponents of poor people science love that phrase, right?
well,
There's no bathwater though.
well, hold on a second.
There's
So,
no
for example,
baby.
hold on a second. Hold on a second. If we take a bite mark, just in the case of a bite mark, and we say it's a piece of chocolate or a piece of cheese, now we
Well,
have
that's
something that we
different.
can do some. Okay,
That's a different substrate.
okay, right. But so now there is a form of, because the quality of the evidence is better. So in the, when we're talking about skin, you said, hey, they, if they're there 2 days later, like in your book, actually, it was pretty incredible. They actually, they dig, they're taking people out of the graves,
Zooming
and
people, right?
yeah, and they're exhuming them, and then checking on the bite mark. So that's pretty
It's crazy.
incredible to me. Yeah. So I'm not suggesting that there are issues with this. I just feel like that there are some opportunities here that need to be explored. And maybe the forensic odontologist came on too soon, too early, with not enough of the background and everything else. But I think today, if we have to approach this problem again, there may be some limitations for sure. But I also think that there may be some opportunities there with 3D technologies, artificial intelligence, a number of different things with machine learning and stuff like that. There may be some other things here. And in some cases, you have to just know where to stop. And I think that's the issue, part of the issue. And one thing I wanted to ask you as well, like on some of these cases, and you sort of fall short in the book, but some of the people who are testifying on the bite mark, I mean, I don't know how else to say it, but it's just criminal. I mean, they are lying. You didn't say that or whatever, but some of the things they're doing, by changing and saying, I can see this, but you can't. You know what I mean? And opinions change, and no rhyme or reason. But um, I can't help but think that there is an element to that. They're making good money, testifying. They want to help in one way or the other, and that's happening as well. So, I mean, did you find? I mean, you mentioned, for example, that you are working with some forensic odontologists, right? So, I mean, are the ones that you're working with, are they just nixing the whole bite mark thing, or are they just saying that, well, we need to do some work here?
No, the ones that, I have, and this has been, I've been working in that community for 10 years. I know almost all of the forensic dentists. As you won't be surprised to learn, I'm not very popular in that crowd, but is that the ones that have dissented and renounced bite marks have recognized the problems that I just pointed out with it. I mean, if you want to talk about chocolate or a piece of clay or something like that, I think that you probably have some probative evidence there. But I've never seen one of those cases, what I mean? And so you can imagine scenarios, what I mean, where, that you would have in a different substrate, what I mean? Because I'm always getting like a dentist to be like, what about somebody with no teeth and somebody with teeth, or like one tooth, and we're making this mark, and then, and then we're eliminating everybody else, and we're just going to include this one person, and like these efforts to save the discipline so they can continue to testify. And that, if it's so obvious, something like that, you don't need an expert witness, right? A lay juror can see that, right? And there's no research that would back up that opinion. And nothing about being a forensic dentist would make you one more qualified than another to opine on that. So not everything is science. Not everything is the basis for expert witness testimony. You know, if you were addressing all these fundamental issues that I'm talking about, and you really got serious about doing the research, then there isn't any organization that relies on valid science more than the Innocence Project. It's the basis of everything that we do. And I don't advance arguments in court that aren't based on valid and reliable literature and the science. You know, because we have a policy agenda. So I'm not like a defense attorney. You know, I'm an Innocence Project lawyer with an agenda to try to bring scientific integrity to criminal courts. You know, that's what I'm trying to do.
Right.
And so if there was something to it, you know, that there was something that you could say, something that might help exonerate somebody, you know, I would be embracing it, you know what I mean? But and I'm hardly an expert in every area of forensics, you know what I mean? But this is all I do, right? And I've read the literature in this area and it's just not there.
Oh no, I'm not suggesting it is. I guess what I'm saying is that I think there are some opportunities where it could be used, and I think there's clearly been some abuses, and there clearly is maybe a lack of evidence and stuff like that on it. Now, of course, the forensic odontologists do things like disaster victim identification, which is different.
It's a valid public service, you know, and I try to go out of my way to talk about the public service aspects of what forensic odontologists do, you know what I mean? And that, you know, is like a kind of thankless and an anonymous job of identifying human remains and bringing a lot of closure to families, you know what I mean? And tons of forensic dentists that I know worked on Ground Zero and September 11th, right? You know what I mean? And that's so honorable, you know what I mean? But then I've also been in court and I write about this in a Fry hearing right here in New York City, where I watched this firsthand being done, where they were leveraging that experience and identification of dead bodies to conflate the difference between bite mark identification and bodies, identifying human bodies, right? And so they made it sound like that they're opposite sides of the same coin. It's like we identify people by their teeth and we identify people by the bite marks their teeth created, right? But that's nonsense, and they're totally unrelated fields. And they've gotten away with that for, 50, 60 years in criminal trials because there aren't a lot of critical thinking going on once you have an expert witness on the stand.
Right. So bite marks, for example, it gets identified. There were like how many cases was you mentioned? There's a whole bunch of cases that were that you guys have helped reverse because of bite mark evidence. It's like 30 something or 70. I can't remember.
35 known wrongful convictions and indictments. You know what I mean? And for a technique that's really little used, you know what I mean? I had never had a bite mark case before I came to the Innocence Project, and I spent a lot of time. I certainly had some hair microscopy cases, you know what I mean? And one of the things that I, point out, because we were talking about how long and how hard, it is to rid the system of really junky science, is that, my first week here at the Innocence Project in 2012 was when the FBI and the DOJ came to us and were ready to concede that hair microscopy had been grossly overstated for a century in criminal courts. But at that time, right, in 2012, there had already been 70 wrongful convictions attributable, at least in part, to the use of that technique. 70, and nothing had been done about it. It was just like then, and I explained how this happened, like the forces that came together to finally have a reckoning around this. But it shouldn't take, people being sent to prison and to death row and people being wrongfully executed, which I also write about, right, to really have a reckoning. This is why we really need to get the validation research out of the advocate's hands, out of law enforcement hands, and into the scientist's hands.
Yeah, that makes sense. Let's talk about the book a little bit. So what was obviously you're dealing with these cases, dealing with people. What was your motivation for writing the book? Was it people were not being vocal enough? Was just lack of information?
I wanted to create a new genre of untrue crime, and and to really kind of dispel some of the CSI myths, that have been going on, for a long time. And I've written a fair number of law review articles and that kind of thing that people don't pay that much attention to, right? And but books are different, right? And and stories are the way that people learn, and I talk a little bit about that in the book, is how persuasive storytelling really is. And I thought that if we had a mainstream book that really relied on the incredible stories that of our clients' cases and some of the experiences that I've had and my colleagues have had, that will bring readers into a tiny courthouse in middle of nowhere Mississippi or in Louisiana or all over the country, and you see the way that junk science plays out in the court every day, and the way that an expert like Michael West is accepted all over the Southeast, even though if you read the cross-examination or the deposition I took of him, you see that this person was being taken seriously and is today in death penalty cases.
Mm-hmm.
So I wanted to bring readers whose views of the criminal justice system or forensics are really based either in their personal experience. I'm sure many of your listeners are forensic experts who aren't responsible for wrongful convictions, that are working in valid fields, that would be shocked by the book anyway, right? And I wanted, readers like, my mother-in-law who loves Law and Order and all the rest, and thinks that I'm a hero because I work at the Innocence Project, but doesn't really get it, right? It's just like, read, this is what's happening, right?
Yeah. So the other part of the book has to do with some of the things that I was reading was not about the junk science. It was about the criminal justice system. And so, being an expert myself and being, having testified on both sides. So you see things too. I think it's changing, but I have seen things as well where it's like, ugh, that's not really sure if they're playing fair here on both sides. So what kinds of things do you believe need to change in order to make things more fair?
We need to end the drug war right now, today. And say, and have acknowledged that this is a public health crisis that's being treated like a crime. And, that reduces volume dramatically. And volume is what leads to a lot of sloppy work and a lot of mistakes and a lot of miscarriages of justice. And there's a lot of junk science used in the drug war, all these presumptive drug tests that people get arrested on that are subjective and often like no better than flipping a coin. People get arrested, they can't make bail, they have to plead guilty to crimes they didn't commit. That happened all the time when I was in the Bronx. So, it's not that those arrests are, not part of the junk science conversation. They are. But we end that, we reduce the volume and and the level of punishment that, we are, in Americans, are so accustomed to 20, 30, 40-year life sentences, for everything, right? As any kind of, crime that has, a tangible victim, a sentient victim, is that we're going to throw this person away, forever, and that punishment, and often, the victims don't even necessarily want that, right? And the community doesn't necessarily want that. And I don't believe in throwing human beings away. And that there's no efforts made to rehabilitate. And, one of the things that I find very devastating in this work sometimes is that I have clients that have been in for 30, 40 years of prison, right? And then even if they were guilty, should have been out a long time ago, right? They're way past any kind of criminality or instinct like that, or past the problems that were, led to an arrest. But like the ones that have been in like in the 80s, 70s, 80s, early 90s, before we had this kind of war on crime mentality, they were able to get degrees. They were able to learn trades. They were able to, make steps to improve their lot in life and be able to succeed, better on the outside. They're able to demonstrate to parole boards that I'm working hard, to get my act together, to be ready to re-enter society.
Mm-hmm.
And because we have such a punitive approach that we've cut off all these programs, so like, I talk about in Stephen Chaney's case in the book when I was presenting with my the legal team his character to the conviction integrity unit. We could talk about all these things that he had done in prison, but they all stopped in like the 90s because they just eliminated all these programs, right? So now today somebody's arrested, you're just going to do time. You're going to probably be subject to a violent, indifferent medical care, a violent society, and that you're never really going to be able to overcome this arrest, right? So, we have to rethink the way that we're dealing with the criminal justice system, period, right? From the top to the bottom, and rethink why we're arresting people, what we're arresting them for, and why.
Mm-hmm. Like in other countries, the like the forensic scientists and the experts and things like that, they work for the court. They don't work for prosecution or defense or whatever. But do you think, like, how would something like that in your mind potentially work or not work? Like, what do you think about that sort of proposition?
It sounds better to me than what we have. Right. So I'm asked this question a lot, and I don't hold myself out as an expert in other legal systems. So I don't really know. I have heard and read a little bit about the so-called hot tubbing technique that they apparently use in Australia, and I think there have been some of that has maybe gone on in the UK a little, but the that seems like a somewhat better of approach. They're court appointed, you have more than one, and they come up with a consensus statement on that. I mean, the group think is a little concerning to me as far as that goes, but that is better than, because defense experts are always viewed as hired guns, and the prosecution experts are always looked at as the guys in the white hats.
Hmm.
And they are arms of law enforcement. We all know that. I mean, a lot of their budgets are tied to police department budgets. Some of them are even paid, as a result of the volume that they get through on convictions. So that's a huge problem, and don't take it from me, take it from the National Academy of Sciences. I mean, and these are, as you pointed out earlier, these are subjective techniques, right? I mean, and we're all human. We're all subject to bias, right? That's part of human decision making, and we can't will
Hmm.
it away. So you have like a whole mindset. As I was watching one of your earlier interviews with Glenn Landenberg, as a scientist I respect, I mean, and but he was talking about how he got into it, right? And he wanted to be an FBI agent. He wanted to catch bad guys, right? And
Yeah.
his mother was, a fan of Quincy, right? I mean, and I write about Quincy in the book, right? And just like that motivation, right, is not a scientist motivation, right? I mean, it's like as scientist is about discovery, it's about research, right? And so that we have to separate that mindset, right? That science is over here, law enforcement is over here.
Yeah. And I think, well, somebody mentioned it in the comments, about good mentorship as well, right? Like just having, sometimes, if you get somebody new on the stand and, they want to help, regardless if they're working for defense or they're working for the prosecution, they feel a need to help maybe, right? And really you help by being truthful and honest and being humble and limiting your opinion to, look, this is as far as I can go, and I can't go beyond this point because now I'm stepping into areas that are going to be unfair to both sides. And so things like that, I think, probably need to happen a little bit better. But I think that's where organizations can help. Like, so, the ABFO, you've sort of criticized them a little bit, but, I'm sure, defense lawyers have their community groups and, engineers have their community groups and stuff like that, that they come together with the goal, hopefully, of trying to improve and be critical of each other and their work and trying to elevate the status of the discipline. So hopefully that will be a part of it going forward. To be honest with you, a lot of the forensic odontologists that I know are some of the most critical about their own areas, and rightfully so. And I remember, I think it was Dr. David Sweet, who once told me years ago. He said, at the beginning, he goes, we thought we had it all. We had the world in the palm of our hands. We had it right and everything else, and it didn't take long to realize that it was a fallacy. There was a lot of issues, there was a lot of problems. He didn't quite say it in those words, but that's what he was trying to communicate. And so I think some of the harshest critics are probably going to be some of those odontologists and different people in different fields too. The work that Dr. Drawer is doing. You mentioned Dr. Drawer as well. I'm not sure if you know him or if you've spoken to him quite often.
He gave me a blurb for my book.
Okay.
And I know him well, and he was an expert witness for us in that handheld tool mark case that I mentioned. He testified maybe 2 months ago in Colorado in that case.
Yeah, I think. I mean, do you find? I mean, are you finding that a lot of experts nowadays are maybe are much more aware of bias and the different forms of bias?
I was interviewing a latent fingerprint expert yesterday in one of my cases, and I was so pleasantly surprised. I mean, is that I'm always kind of, step gingerly into this area with experts, particularly ones with whom I'm working. And because I often, will have outright rejection of, this is impossible for me to have been influenced by this, I mean, as though they're not human. And this expert wasn't like that. And it was so, and I had him do his analysis blind, like I do all of the experts that I work with. And many of them get very frustrated with me. I was like, listen, I'm not going to tell you anything about the case. I don't want you, I'm not saying I want there to be a match or not to be a match. I'm not saying this is my client or the victim. I'm not saying none of this. I just want, does this evidence, advance the ball or not? And if not, I'm going to take whatever it is. And, and I, and sometimes, I'll be questioned about it as a litigation strategy, and what I always say, is that what I do is when I elicit this opinion on the witness stand, I elicit the fact that my experts know nothing about the case. Literally nothing. They don't know who my client is. They don't know if it was a murder or if it was a rape, if it was a shoplifting, right? Is they have no idea. And they're not going to be cross-examined about bias on that because there is none, right? Is they did it completely blind. And then I'm going to cross-examine the prosecution's experts about everything that they know about the case. And if they're not lying, almost always they know a whole lot about it, much more than they needed to do the assay at issue.
Yeah, usually. I mean, it's a common problem that I get too. Like they'll call, somebody call you and they'll say, I shouldn't tell you this, but, and then they go on and they tell you anyway, right? So it's like, okay, what do you do, right? You say, hey, shut up, or sometimes they'll ask, or sometimes I'll say, like, you know what, better not to tell me. Give this is the information I'll need, and just hold off a bit on that.
It makes you much more credible as an expert, in my view. And it much more credible. And it's hard. Is what you see, and this is really, really telling, is how many inconclusive decisions that there are when they really have nothing else to base it on but the evidence in front of you. Then it's harder to make a decision.
Let me ask you about the book. So that's the book there. I just want to show people. Okay, it's Junk Science. You can get it on Amazon. You get it all the respectable places online, and it is a really good read. It's eye-opening in some cases, and I know that other people are commenting on it. Actually, there's a comment right here. So somebody's halfway through your book here. Rob is, which is great. So what you said you wrote another book, and I'm just curious about this one. So when you write a book, there's like a book tour, right? Are you doing that sort of thing?
Yeah, I've been all over the country. I'm going to be in Canada in October in Vancouver. I've been to, it started in Brooklyn, Phoenix, LA, San Francisco, Minneapolis, Philly, Baltimore, DC, Gaithersburg, Atlanta, Oxford, Mississippi, Boston, Seattle. So yeah, I've been around. I'm doing shows like yours. I've been really gratified with and including, many folks from the forensic community who have talked with me about it, and have found it, some have been pretty pissed off about some of, but I tried, but most, have been, interested and wanted to talk about, some of the issues that, I haven't had like bite mark experts talking to me about it, but I was trying to be very careful about which particular techniques I talk the most about, which I think are kind of indisputable about some of the really real serious problems that have been associated with it, and then tried to be fair. Where I thought that the others were, there was a question about the misapplication and talking about misapplications, which are different, or bias, which is just because you're biased doesn't mean you're wrong also, right? It's like detail drawer likes to say that, right? It's like, so that's true too, right? But the idea is that this is such a simple fix, right? Often I'm asked about, what can we do to improve, right? And so I'll talk about, we need an entity to do this testing, but there's really a very simple test is you have blind testing, right? And that's a cost-free approach.
Right. No, that makes total sense. We're getting on in time, but I do have just a couple quick things. So first off, if people do want to get involved or they want to, offer their help or services, what's the best way for them to do that?
Well, I think that to the extent that your audience, and I think it does include numbers of experts, is that, I work with expert witnesses all the time, and I will never ask any expert to shade any opinion or to do just the way that we were talking about that, and so, sometimes we pay our experts. Many of them work pro bono on our behalf, which of course is greatly appreciated. And, if you want to, you can reach out to me directly if you're interested in working with us. I'm on Twitter at Chris Fabricant, and I'm on Instagram, and I'm on LinkedIn, all these things. I used to not be, and then I wrote the book, and now I am. But so much more easy. And then, for, other folks, serve on juries, be skeptical, right? Just because somebody's wearing a lab coat doesn't mean they're right. And that it's important to me, the jurors always talked about, bringing in your common sense, and that's what we're relying on. And that also means not to turn off your critical thinking skills when, an expert witness is on the stand. It's impossible to me that nobody ever thinks about yeah, that bite market changed 100 different ways and we have no idea how. And nonetheless, they were so persuasive, I was just
Right on. Well, look, Chris, I want to say thank you so much. Great interview, great information. I wish you all the success on the book. Very well done. It was a good read. The cases were very interesting, and you laid it out really well. It was a good read. So thank you very much.
Thank you, Eugene. Thanks very much for having me.
All right. Hey, hang back for a sec. I'll come back to you.
Okay.
All right. Thanks. All right, folks. Well, that's it. Some really good information there. Yeah, really intrigued with all the work that Chris has done and some of the cases. Very interesting. And as an expert witness myself, and I can see in the comments there's some of you there who are also doing this type of work. It always helps to take a hard look at yourself and your discipline, and where you go from there. So that does it for this one. As the summer is coming up here, trying to do this weekly is very difficult. So it's going to be a little bit more broken, but rest assured there's going to be a few more coming up over the summer. So thanks so much, everyone. All the best, and we'll see you soon. Bye-bye.